Welcome everyone to Suffolk Credit Union's estate planning webinar. We are about to begin. Before we start, just a few housekeeping items. This session will be recorded. Therefore, all attendees will be muted. Don't be shy. We are here to help. Ask any questions throughout the seminar by using the question feature. For safety purposes, the chat will be disabled. So again, please use the questions feature. My name is John Spiegelman. I'm the branch manager of Suffolk Credit Union in Miller Place. I'd like to thank everybody for joining us as we cover very important topics. I'd like to introduce Craig Andreoli. He is the founding partner of Andreoli Law Group, PC in Islandia, New York, which he co-runs with his wife, Christine. This firm specializes in elder law and estate planning, offering a unique approach inspired by Craig's personal experiences. He is a graduate of New York Law School and admitted in the New York State Bar and U.S. District Court, and is an active in several bar associations. We thank Craig for joining us this evening. I'm going to step it over to Greg.
Thanks, John. Appreciate the introduction. Good evening, everyone. I appreciate your time tonight. I'll try to be as informative as possible. Please feel free to ask questions, as John suggested. I love doing Suffolk Credit Union educational speeches and workshops like this because of my history with the bank. I have 46 years ago, when I was 12, my father, a county employee, opened up a little savings and checking account at Suffolk, back then Federal Credit Union, and to this day I still have that account. I still bank with the bank, and I was fortunate enough to meet Mark Filiberto along my journey there, and I just want to call out to Mark, if he's out there, that he's associated with the bank, and few people in this industry, in the financial industry, have the moral compass Mark has when guiding his clients and customers through this financial process. So if you have not met him or his team, I would encourage it. He's a good guy. He will not do anything wrong on your behalf. Anyway, tonight they've tasked me with talking about trusts and wills and basic estate planning. What I found over my experiences is that people don't understand trusts. And since I only have an hour to discuss these topics, I do want to spend a good amount of time on trusts. But I do want to lay the foundation first before we dig into trusts and the different types that might be appropriate for you or not appropriate. When it comes to an estate plan, you have to start somewhere. And an estate plan really starts with, what are your goals? And a good estate planning attorney will help you identify where you are, identify what your goals happen to be, and try to find paths for you that are meaningful to accomplish those goals. But most of the time we start at what I call the foundational documents. If you have these 4 documents, then you can cover many of the typical issues that occur during estate planning. Those 4 documents are the last will and testament, power of attorney, healthcare proxy, and the living will. Please don't confuse the living will with living trusts or with the last will and testament. It's neither. But I will explain those. The power of attorney, healthcare proxy, and living will are designed to address your decline. So not all of us are independent and cognizant and have the ability to make decisions on our own. Sometimes we go into a decline where we actually lose the capacity to make decisions on our own. So before that event takes place, it's super important for you to have a voice and name legally and empower legally the people you trust to make those decisions when you're at your most vulnerable, whether that starts with a spouse and then falls over to the mature children, if it's brothers or sisters. It's best to have this voice, because if you miss the opportunity to have these documents put into place and you do slip into this state of not being able to make decisions on your own, my experience has been the people you least want come out of the woodwork to petition the court in a guardianship proceeding to take over decision making for you, because they think there might be a little windfall in it. Now, that's not true of everything, and I am jaded because I see the worst sometimes in families, but no need for that. No need for an expensive guardianship where the court's going to just pick the first person who petitions. Get these documents in place, have the voice that you need to have, and put the right people in the right seats making decisions for you. So healthcare proxies, if it's medical decisions only in the event you can't make your own medical decisions. You appoint people close to you and they will do that. And the healthcare proxy is all about making decisions to get you back healthy and home. If something bad goes on, like a coma, the living will is a document which compels the hospital to remove the machines that are keeping you alive to let you pass naturally. If it's not a medical decision between the healthcare proxy or the living will, then it falls under power of attorney. You just need to know that power of attorneys can be drafted in a lot of different ways, and you want a power of attorney that's going to meet issues or enable your agents to make legal decisions for you when you can't on all fronts. Filing for government benefits, creating legal documents on your behalf, perhaps transferring assets in and out of your name to preserve them. All of that falls under the power of attorney if drafted correctly. Okay, but let's get to the superstars of the show. Most people, when I meet with them, are interested in what happens to my stuff after I pass away. So power of attorney, healthcare proxy, and living will, they're all about helping you while you're alive. And after you pass away, so do those 3 documents. The last will and testament is a distribution tool that says who gets what of your stuff, in what percentages, under what conditions. But what people, and the reason it's a foundational document is because if you do nothing else, if you just rely on your will as your distribution tool, it will distribute all your property. Now, please, another conversation for another time is if you don't have the will, just know bad things happen. If you have the will, that's the voice, you're picking the right people, you're choosing the accurate distribution method. But the will is actually only one of 3 ways to distribute assets. And depending on what your goals are, we may want to use some of the other distribution methods over the last will and testament if it's more in line with the goals you're trying to achieve. So what are those 3? The 3 are placing beneficiaries on your financial accounts. So if you have a savings account at Suffolk Credit Union, maybe it's co-owned with a spouse, and you can put your children on as beneficiary. And beneficiary designations, it could be anyone, it could be your butcher, it could be your neighbor, it could be your children, it could be your nieces and nephews, and it could be in different percentages. And a lot of times they even allow you to say, well, if this person's not alive, go to the next level, like to their children. And we like beneficiary designations because it's free. Suffolk Credit Union or any institution that you bank with is not going to charge you for beneficiary designations. In fact, they should be asking you who would you like to be on those. And you can put those on life insurance, you can put it on on annuities, you can put it on savings accounts, on CDs, whatever it is. We want to try to place beneficiaries on there perhaps because it's free and more importantly, it's fast. Within a couple of weeks of showing the bank the death certificate, they're cutting the check to your beneficiaries in the amounts that you want them to. And most people have that, but they don't realize it's one of 3 ways to distribute assets. Where beneficiary designations don't make a lot of sense is if you're seeking some additional control. So I have 2 sons in their 20s, and it's comical how dopey they are when it comes to decision making. So I don't want to give an inheritance tomorrow to them. I think they're still just slightly too young. There's glimmers of hope for them, but they're still making dopey decisions. So I'm actually sending my inheritance over to my brother as a trustee to provide financial oversight, make sure they have the money they need to survive in education or health or rent or transportation. But I'm not giving my children at this young age the right to make their own financial decisions, because I'm afraid it's all going to go to Grubhub and some sort of online gaming thing. So if that's your situation, beneficiary designations on your account don't work very well because they're either on the list and get their percentage of inheritance, or they're not on the list at all. Another bad person put on beneficiary designations are if you have a special needs child and you know that in the future or currently they have some sort of government benefit that's paying for certain services. Well, beneficiary designation, if that child's name is on that savings account, he's getting his share. And if that disrupts his government benefits, disrupts his government benefits. It's something that we can't stop because you've made a contract with that financial institution saying, hey, when we're gone, they show this death certificate, give them their share. So if you need more control or it's inappropriate to actually send it their way, then beneficiary designations don't really work that well. And again, it could be other reasons. It could be drug or alcohol addictions, or maybe they're spendthrifts, or maybe you hate the in-laws, or I don't know, a myriad of reasons why you wouldn't do it. But if they're fiscally responsible, you should strongly consider simply placing beneficiaries on everything you can to avoid attorneys, probate, delays, notifications. Okay. The next one's the will. The will is a process where the will's funny because so what goes through the will typically? Well, anything you can't put a beneficiary on goes through the will typically. So that might be your real estate, your timeshares, your personal property, your jewelry, anything, your cars, ATVs, boats, anything that has some sort of title or even anything that you can't put a legal beneficiary designation on, or chose not to put a legal beneficiary designation on, can be governed by the will. The problem with the will is how it works. The will is merely a set of instructions. So the way a will works is you name an executor, and then that executor has a job to do after you pass away. And their job is to become legally empowered to sell your house maybe, or marshal your assets in some way, and then pay off your creditors that are valid debts. And then whatever's left over, they're supposed to give to your beneficiaries in the manner you want. So using my example, my executor would marshal my assets, sell my house, and hand over the proceeds of that sale to my brother, who's the trustee for my two boys. And his job is to set up 2 trust accounts and provide for my sons until they reach a certain age, at which time he will transition over to my boys the right to make their own legal decisions with that. Okay. To make that happen, since the will is only a set of instructions, the executor needs to seek the legal authority to do things like sell the house, because he doesn't have the authority just because he's named in the will. He gets his authority from surrogate's court, and the process of seeking that authority is called probate. My 32 years of practicing, I've never had anyone go through a probate process, lean into my ear and say, hey, Craig, thanks, that was a real treat, right? Because probate isn't that environment. At best, it was, okay, we survived, it was okay, it was slow, we waited, we spent more than we thought, and its very worst, it was completely contested, it was locked up in probate for years, we're still working on it, we still haven't seen a distribution after 7 years. It can get really bad, and that's just the way it works, because you have the government involved. Surrogate's court government has rules and process that need to be followed before they're going to legally empower your executor to do their job. And if you don't have an attorney in the family, courts are not going to let you do it on your own unless it's less than $50,000. And that means you have to hire an attorney, and attorneys don't work for free. And the more you tell that attorney to get your executor empowered to do their job, the more they're going to charge you. So already we have this skeleton, this basis where there's a lot of hands out that need to get paid just to get your executor entitled to start to do his job. And then, so my example, if my executor, who's my brother, gets legal authority, he then has to hand it over to himself as trustee. And the courts are going to say, whoa, if you have a trust, we may hire a person to review your initial accounting. And then we're going to hire someone to review your annual accounting. And then when you finally, hand it over to the beneficiaries outright, we want to see the final accounting. See, the court's looking for oversight. They want to make sure that that your trustee isn't using your children's beneficiary for alcohol, drugs, or tobacco or something, firearms, I don't know. So they the court has this, right? Because if that beneficiary is a 2-year-old or a 3-year-old, the court feels necessary to have oversight of what that trustee is doing. Sometimes that's a good thing. You want that oversight. Sometimes you feel like, I trust my brother. I don't think he's going to do that. So there's a time and a place for everything, but know that every time the court wants oversight, you have to pay another person, and your heirs are getting a little less of an inheritance. It all gets chipped away at. So if I'm rattling on a long time about probate, it's because I make no bones about it. If you can avoid probate, it's normally the better situation. Now, I know there's fine probates that happen and people say, I didn't have a big deal in probate. That's great. I will say the majority of the ones that we have ever done, seems like there's always some sort of hair. There's some sort of mistrust. There's downtimes. There's just delays. There's notifying of creditors. There's silent periods, and silence breeds paranoia, and paranoia breeds trouble. The system is just difficult, I should say. Anyway, but you can stop right there. It's going to get the job done. My 2 boys are going to get their share. It's going to be 50-50. They're going to be oversight by my brother. And at the end of the day, they're going to transition at 30 and have the right to make their own financial decisions. But the process is cumbersome. Okay. We're at the end of the foundational documents. So we don't need a trust yet, right? In my personal opinion about trusts, I didn't tell you about probate and the cost and the delays and the fees. And I have 100 probate stories that would sour you against probate. The notification, creditors, and things that happen that are lousy. But in general, just know that probates in general can be very expensive, even routine ones. All right, so I'm starting the topic on trusts. And trusts are, in my personal opinion, I started to say, is that not everybody needs a trust. I think you start thinking about a trust only if a will and beneficiary designations aren't meeting some sort of goal that's important to you. Now, that goal can be as simple as, I want to avoid probate. I want to avoid all this nonsense the court. I mean, the attorney I saw a seminar with the attorney, and he bashed probate for 10 minutes. I feel like maybe your trust is the way to go. So there's something, you have to have a goal, okay? And if that goal is to simply avoid probate, then we have to talk trusts. So I'm going to describe 2 types of trusts today. I think that most people gravitate towards 2 types of trusts, but you need to know that there's hundreds of trusts. And trusts can be drafted in a lot of different ways to do a lot of different things. And I always look at the slide and I wonder why I put it in here, because it looks too colorful for this kind of workshop. But I think that the point here is trusts are like ice cream. We know you're looking for a dessert, but I don't know what flavor is right for you. There are living and testamentary trusts, there's revocable and irrevocable trusts, there's ones that hold life insurance exclusively, there's ones that deal with Medicaid, and there's ones that have supplemental needs. I mean, there's trusts all over the place for a varied of mirrors. And so, not to confuse, I want to boil it down to just 2 basic trusts. The first one I'm going to talk about is a revocable. If you had to give it a title, it'd be a revocable living trust. And I hate titles to trust because it's the provisions under the title that are meaningful for your situation, right? It's the conversation that's important about what your goals are so that the attorney can then put the proper provisions into the proper documents. But I'm going to give you a very general, simple explanation of a revocable living trust, which is usually one of 2 trusts that most people gravitate towards. And this trust's sole purpose is to detail your distribution strategy and avoid probate. So the first thing we need to understand is, what do we put into this type of trust? Well, we would put anything into this trust. First, we would certainly put in property that would otherwise go through your will. So we're going to put in your house or your second home or that vacation lot in Virginia or whatever it is. Things that definitely would go through the probate process, we want to put to this trust if we can. I wouldn't get bogged down with automobiles and cars and things, but you can deal with personal property in these types of trusts, so artwork, jewelry. And depending on what your goals are, you can also transfer your Suffolk Credit Union accounts into this type of trust, or at least name the trust as a beneficiary on your accounts. The only thing that doesn't go into these trusts immediately would be retirement accounts because of some tax consequences. Your retirement accounts usually stay out of these types of trusts, but you could put your non-qualified or non-retirement accounts into these trusts, or you can name the trust as a beneficiary. And the purpose for doing that is because we have a very specific distribution strategy we want to follow. So if it's, in my example, I want to get 2 trusts established for my boys until they reach a certain age. Well, the trust can only distribute trust property. So I have to make sure there's something in the trust so that my brother could distribute it. Otherwise, it's going to go through the will, which is the probate thing I'm trying to avoid, or I accidentally named them as beneficiaries under my financial accounts, and they're going to get that money outright with no legal oversight. So you have to physically put or send assets to a trust. So the way we do that with a house is we redeed the house from whoever owns it now into the trust. If it's a savings account or a CD, it would be an assignment of that if it didn't break any contractual stuff. Or, like I said, you can name as beneficiaries. So when you pass away, the person who's responsible for those assets are the trust. Now, the trust is comprised of 3 people, basically, 3 entities: the creators, the trustees, and the beneficiaries. For a revocable living trust, usually, the parents, mom and dad, or in my case, would be my wife and I, we become the creators. And as the creators, we have 2 jobs. One is I get to create the terms of the trust. What happens to trust assets while I'm alive? What happens to trust assets when one of us passes away, my wife or I passes away? And what happens when the second of us passes away? What happens to the trust assets? So we get to design the game plan. After we design the game plan, then we have the only people, the second job we have is to put something in it. And we already talked about that, the house, maybe some accounts. Then our job as creator is over. The people who can touch trust assets, who can pull money out or put money in or do whatever it is, are called your trustees. And trustees have to follow your instructions, okay? This type of trust, you would normally name yourselves as trustees. So if you're the creators, you would name yourselves as the first set of trustees, and you would give yourself the rules of something like no restrictions on trust assets while either of us are alive. Okay, and that's like outright ownership. So you have full control over your house, over the money that's in the trust. You can pull money in, you can take money out, you can leverage your house, get a line of credit, paint it purple or burn it to the ground. Doesn't really matter because you have full control of trust assets as the trustee when you while you're both alive. And that can continue when either one of you is alive. Keep in mind the main difference between a trust and wills are that a trust is developed from a different set of laws. When I draft a trust, I'm following statutes that deal with trusts. And if I create a trust properly, there's a lot of known properties of trusts that occur. They're very known, settled types of instruments. And one of the virtues of a trust is that the second the creator creates the trust and the trustee countersigns that document, the trustees are legally empowered to do their job immediately, right? So if I put my house in the trust and I'm the creator and then name myself as trustee, tomorrow I can go and get a line of credit on the trust, on my house. So, right, everyone recognizes me now as the trustee and have the right to touch trust assets. So unlike you, what happened, the trust doesn't die. The only thing that happens is your successor named trustee or trustees replace the existing, replace the void that you left when you passed in that trust position. And that new trustee is legally empowered to do their job the second you pass away. So we hope they're at your funeral, but they could be selling the house the very next day, right? So that's what's that immediacy where that trustee can act immediately upon them stepping into that position That's what the whole probate process is about. Your executor seeking legal control from surrogate's court to do their job. Here, right away, the trustees are legally empowered. The only difference about when the second of you passes, in my example, is that your trustees have to follow a new set of instructions, which are, hey, set up two trusts for my boys, oversee their money until they reach 30, whatever your distribution strategy is, that the new set of trustees have to follow that so that they can't change the terms. But they have the right to do their job immediately. And that's how we avoid probate, because they don't need an attorney, they don't need the court system, they don't need to notify creditors, they don't need to notify family members that aren't named in the trust. So these trusts are very, very popular because they avoid probate. The ease in which you get assets from the trust to your beneficiaries is as simple as a beneficiary designation to the bank almost. They are private, so if you're cutting out a child or you're doing an equal distribution or whatever, you can no one's overseeing that. There's no notification requirements to someone who's not named in the trust. There's all sorts of ways we can draft these revocable trusts to do a myriad of different things depending on your goals, and everybody's goals are a little bit different. So super popular, super convenient, and super effective at making a transition of your assets when you pass to your intended beneficiaries. Okay, so that was a revocable trust. There's another really popular trust out there, which is an irrevocable trust. And I'm talking about people now that have less than $7 million of total assets. Most of my clients are in that range. So this is more geared towards the mass, more of the population that isn't as affluent as $7 million. There is another irrevocable trust that seems to be really popular, and it has to do with healthcare.
Greg,
As we grow, I'm sorry, is there a question?
Yes. So is it better to put your assets in a trust sooner than later, regardless of my health issues, if any?
I'm not hearing you very well. Can you repeat that?
Is it better to put my assets in a trust sooner than later, regardless of my health issues, if any?
Well, we're going to talk about this irrevocable trust. Everything is maybe. Keep in mind, I am an attorney, and everything is fact specific. And these trusts can be drafted in different ways to meet different criteria. Sometimes there's risks that we need to do. And after you hear my irrevocable trust speech, I might have already kind of answered it because you'll know all the background of your particular situation. So with long-term care, first of all, comes in three flavors, basically. It's having an aide come to your house. It's assisted living facilities, where you get out of your house and you live somewhere where they have more assistance for your health. And then there's the dreaded nursing home. And nobody wants to be in a nursing home, but they're all full. And that's because your health dictates whether or not you wind up there. If it's not a safe environment at home and you can't get the help to stay in home, sometimes you wind up in the nursing home. More often than not, and it must be because, like I say, they're full and they keep sprouting up. And there's only three ways to pay for these services. They're all expensive, and there's three ways to pay for them. One is private pay. And most of my clients are saying to themselves, hey, Craig, look, if I have to pay for the cost of long-term care, my well spouse isn't going to enjoy retirement. Or I'm not going to leave the legacy I was hoping to for my children. Or I don't have a pot of gold for myself to make sure my quality of life is beyond just care in the house. These are older numbers, but this is not unusual range for these services. So if you want an aide in the house, it's currently about $35 an hour. Depending on your needs, it can easily go up to $8,400. Round the clock type of care. Assisted livings, a Bristol would be $10,000 a month, and there are some assisted living facilities that accept Medicaid as a payment source, but there are some assisted living. $3,500 is probably definitely on the low side. And then nursing homes, we're constantly seeing $20,000 a month. So if I can't privately pay for those services without it being a fiscally crippling event, what were my other two options? Well, Like the other one is long-term healthcare insurance. And you need to talk to someone, people at Suffolk Credit Union, about long-term healthcare insurance, because that's one of those products, you got to get it early. Otherwise, most people, it gets pricey and they price out too quick. I have my own personal opinion on long-term care insurance and when to get it and how to get it. All I know is that I'm a fan of it. There's various types of it, but I also understand that it is difficult financially for a lot of people. So talk to the experts who sell it, make sure, because they're going to give you that information at no charge. You can even go for a test to see if you're eligible and what the fees and pricing would be. And then you can at least have the knowledge to add that to your decision-making formula about whether long-term healthcare insurance is appropriate or not. But I will say the majority of people that come through my door, they don't have it. So if you're not privately paying and you're not insuring against it, Medicaid is the only it's the only way to pay for those services. And just so you know, Medicare and catastrophe insurance, what's it called? Not catastrophe, but anyway, all of those other insurance plans basically only give you 100 days. When I'm saying long-term care, this is not a situation where you're going to rehab and come home. This is dementia, Alzheimer's, Parkinson's, MS, frailty because of age. Whatever it is, we expect it to need attention beyond 100 days, and we're not expecting it to go away. That's long-term care. So Medicaid becomes the only payment source out there for a lot of people. So we want to position ourselves to use Medicaid as a payment source in the future if we need it. Whether or not you actually use it, that's up to you. But we need to know Medicaid, how it works, and what the interplay is with an irrevocable trust. So I'll try to do this. I hate talking about Medicaid in too much detail because Medicaid's complicated and it's ever changing. But Medicaid basically comes in two types: community care Medicaid and chronic care Medicaid. Community care Medicaid will pay for an aide to come to your house. And they're custodial services. They're not taking blood pressure. They're not PTing you. They're not nurses. They are there to make sure you get in and out of bed safely, that you're going to be comfortable, that you're going to be cooked the proper meals, you're showered appropriately, those type of things. They will pay for the handful of assisted living facilities that accept Medicaid as a payment source. Amber Court, St. John's has one now. Anyway, there's a couple of that are out there. And that's community care. Those two come under the community care model. Chronic care is exclusive to nursing home care. Now, Medicaid, the way it works is like a bank. If you qualify, they will lend you the money you need to pay for those services. But when you pass away, they want to force the sale of your house and recoup what they paid out from your probatable estate. Okay, so if you have any money that goes through your will, the first creditor on that list is going to be Medicaid. It's also a welfare program. You have to be poor to get the benefit. All right, so I need poor, and I'm going to try to stop the recovery. So the only pre-plan we have, the only technique, is to make this trust irrevocable. What we're doing is we're trading flexibility for protection. We're trading some convenience for protection. Irrevocable trusts meant for Medicaid planning have certain restrictions that you need to know about. But the trust does two things. One, it makes you look more poor on paper than you actually are. And two, it'll thwart any recovery efforts as long as the asset has been sitting in the trust further than the look-back periods. All right, Craig, what's a look-back period? This is why I hate talking about Medicaid in too much detail. A look-back period is, since it's a welfare program, the easiest way to get poor is to give away your money. So a look-back period is when Medicaid says, whoa, it's inappropriate for you to give away the money and have the taxpayers pay for the bill if you had that money. So anytime we find that you gave away money Every time you give away $15,000, you have to privately pay the nursing home 1 month. And we'll audit your finances for a period of 5 years. That's the look back. We're looking back to see if you made any gifts. And we're going to tally all those gifts that happened in the last 5 years at the time that you're applying for Medicaid benefits. And we are going to penalize you by forcing you to privately pay for the nursing home 1 month for every $15,000 you gave away. So if we gave the house away, then that's a lot of $15,000 increments. That's bad news. So the key to these trusts are plan early and get beyond the look backs as soon as possible. The longest look back right now that we have is 5 years, and that's associated with chronic care, the nursing home care model. So if you want Medicaid to pay for services, you have to be below $31,000. That's their poverty limit for one individual. And you had to have been that way for a period of 5 years. Okay, so where does trust play a role? Oh, I should talk about community care. Community care historically has no look back. So community care has always been wonderful because if you needed care at home, which is where most people want to be, we had the right to just give away your money to a child, the butcher, a trust, right? And you could qualify for Medicaid the next month. We could intentionally make you poor, and Medicaid didn't care. We're on the cusp of that changing. There was a law passed back in 2020 implementing a 2.5-year look back for community care services, care at home. But it was never activated because of COVID restrictions. We are over COVID restrictions. It's now time where New York is trying to implement this 2.5-year look back. Usually New York State's budget comes out in April, I think. It's in that bill, the proposed bill, that we start activating it this year. My best guess at this point is September, but I don't know for sure. But it seems likely that they're going to implement this 2.5-year look back for home care. So that means even for home care now, you can't just give away assets and then have eligibility the next month. We have to make these transfers or get rid of assets 2.5 years beforehand. So if I'm going to give away money, where do I give it to? Well, that's these trusts. These trusts have all sorts of benefits and protection and control than, say, giving it to a family member. And we want to give the assets to these trusts before you file for Medicaid, after the look back periods have been cleared. Okay, so one, these trusts prevent that recovery if you actually qualify for Medicaid benefits. But they also make it look more poor on paper, is what I'm saying. So let's say you've got $500,000 of non-qualified investable assets, non-retirement accounts. If you tried to file for Medicaid benefit, and we put the house in this type of trust, your house, which is a great asset to put these trusts. And then you have this $500,000 outside the trust. Well, if we didn't put the 500 in the trust also, or some portion of the 500 in the trust, when you file for Medicaid, you're going to present like you're a $500,000 person. And it's hard for me to get you from 500,000 down to 31,000 without some loss of money. So we have a conversation when we establish the trust. We know we want to put the house in, but maybe we say, you know what, we're also going to put $350,000 or $400,000 into the trust as well. Why? Because if you present to Medicaid, you now look like a $100,000 person, and getting you from 100,000 down to 31 is a lot more chance that we'll lose much less. Now, houses in the trust, you can sell your house while it's in the trust. You can, you have the right to live in the house. You can't get kicked out of your house. Your trustees can't sell the house without your permission. You have all protections. You don't lose your enhanced star. When you sell the house, you can use the proceeds to purchase a new house. My mother-in-law is 90. For some reason, she takes all her legal advice from her beautician. And once in a while, she'll run to me and say, Craig, the beautician's saying we should have our house in an irrevocable trust. What are you doing? And I have to remind her, well, Mom, we did that like 15 years ago, right? She doesn't know or doesn't remember because her life's never changed by that house going into the trust. She pays the bills just like regular. She maintains the house. She doesn't ask the trustee for anything. So houses in these trusts are just really good assets to put in there. Money gets a little bit more complicated because these trusts, you can't be your own trustee. You have to have someone else be the trustee. It can be a child, and that child can be a beneficiary as well as the trustee. And we like to describe these children as bobblehead trustees. So they're supposed to just listen to what you want them to do with trust assets, right? So if you say, hey, switch from mutual funds to commodities, their head's just going to bob up and down and say, okay, right? They're there to just listen to what your wishes are. So you have this indirect control. As long as your children are listening to you, then you really aren't out of control of trust assets. Now, if your child trustee doesn't listen, which shouldn't happen at all because you've invested in this type of trust, you've worked with an attorney, all so that this child can get more of an inheritance, basically, right? It's a gift to them more than anything that's going on with you, because if you're independently rich, why would we tie up assets in this way? So we expect the child to comply with whatever your wishes are. But if they don't, one of the nice attributes of these trusts is that you get to fire them and you put someone in place that'll do what you want to do, right? So if you want to sell your house and the kids are not signing the contract of sale and have no intentions because they want a beach home, they want a summer house here in Long Island, you would just simply fire them, put someone in place that will, and you can put them back on once the deed is done if you so choose. You could also change beneficiaries. When you put money in the trust, you're not supposed to take it back out. The best thing you have, the best you can get is a stream of income from the trust. So if you have that $400,000 in my example, and someone from the credit union is guaranteeing you 28% return, then you get that 28% return. Probably more conservative, the 4, 5, or 6% range, but you would be able to pull that from the 400. But there's no expectation that you should be taking any portion of the 400. In fact, your trustee giving you any portion of the 400,000 will make this trust will lose its protective attributes. The reason I say it makes you look more poor on paper than you actually are is because we know where the 400 is. It's sitting right in the same investment that it was in before. It's just now a trust account. And if we need principal, the mentality should be break glass in case of an emergency. But all you have to do is ask your child trustee, I need money from the trust. I need 30,000. For some reason, it's an emergency and I need 30,000. Well, your child trustee just simply takes the 30,000, gives it to himself, declares that a gift, and then he turns around or she turns around and pays for or gives you the 30,000 you're seeking. It's a two-step process, but it's completely legal and completely doable to get money out of the trust in an emergency. But I'd much rather put less in the trust than overfund the trust and have to keep trying to get this money back out. If you needed the money, why'd we put it in the trust to begin with? But if long-term care is an issue for you, or the payment of long-term care services, an irrevocable trust like this should be the conversation. If you're just looking to avoid probate, then the other trust is a lot more flexible and you have a lot more control. That would be the appropriate tool for you. Both of them avoid probate, but one has more restrictions on what you can do with the trust assets, and it's designed really to position you for Medicaid payments. The other one is more just to avoid probate and have flexibility over the distribution strategy. So I know I've given you a ton of information and I tried to simplify them, but trusts in general are complicated. Medicaid's complicated. Estate planning can be complicated. It's best to sit down with someone, make sure that you express your goals very clearly, and let them give you several scenarios on what might be appropriate for your situation.
We have another question, Greg.
Yeah, because I'm wrapping up.
Do successor trustees only apply to revocable trusts?
No, so you can have co-trustees, you can have an independent, you can have one trustee, two trustees, you can have them you can have them act first and then second, you can have a third level of trustees. All trusts have trustees, and I like to build some depth if those people are trustworthy, because your document will last longer before you have to ask the attorney to go back and amend it. So the answer is both trusts can have successor trustees, but neither needs it. But it would be preferable.
Are there
Any other
any
questions?
additional questions? Please put them in the question box. We have another question. How much do these 4 important documents usually cost?
So, there's a lot of attorneys out there that have a lot of different practices, and they're going to quote a lot of different prices. I can only talk about my practice, and I hate making fees a subject of an educational speech. I always offer this. Our firm doesn't have a consultation fee. I'm willing to spend 1 hour of my time, if you're willing to spend 1 hour of your time, to have a conversation, to be a meet and greet, to ask the questions I need to digest what your needs and your goals and what your plan might be. And at the end of that complimentary consultation, I give fees and process at that time so that you can add that to your decision-making formula. So, but trust can range, anywhere from probably 2,500 to 16,000.
How do you decide which kind of trust is right?
A conversation with someone who understands trusts. If I could simplify it based on my seminar here, it would be, if you're concerned about long-term care costs, you should explore the irrevocable version. If you're not concerned or you have long-term care insurance, then you should pursue or ask questions about the revocable trust.
And we have another question. If you have a mortgage on the trust, can you have a mortgage on the trust property?
Yes, absolutely. The biggest downside to the irrevocable trust only is that you can't get additional financing. So if you have a mortgage already, that's fine. But if you wanted to refinance that mortgage, you couldn't. If you wanted to get a line of credit, you couldn't. And you couldn't renew an existing line of credit. That's just for the irrevocable one. The revocable one, any type of funding, loans, HELOCs, I'm pretty sure they're fine.
We have another question. Which trust is preferable for dealing with look back?
The only one that creates a look back is the irrevocable trust. There's no look back on the revocable. Medicaid deems everything in a revocable trust still yours.
What if you are collecting disability benefits and already get Medicare at the age of 61?
You get Medicare or Medicaid. So these trusts are meant to get Medicaid for long-term care services. It's not a supplement to your insurance. If you're on Medicare, it's because it's been accelerated because of the disability, and your Medicare is your medical insurance. It'll only go out to 100 days. So Medicaid would pick up from day 100 moving forward. Hopefully that answered your question.
Are there ongoing trust fees?
In the 2 types of trust I discussed, no, there's no trust fees whatsoever unless the trustee you've chosen wants to take commissions, but you have the right to tell them not to. It's not the type of trust where you need an attorney oversight or have annual meetings with the attorney to get anything done through the trusts. There are exceptions to everything, obviously. So if you have a corporate trustee, because you don't have family members that you trust to make decisions, they pay a fee. They charge a fee and things like that. But in general, no, there's no annual or maintenance cost to these trusts.
Is the look back period from the date of application to Medicaid?
Yes, it's from the date you apply looking back. If you're on the cusp of filing, we do a lot of Medicaid filings. If you're kicking around needing home care or not, and you're like pretty much there or you need services soon, don't wait. You got to get it now, because if you file for Medicaid community care benefits prior to this new let's say I'm right with the September date, which please don't quote me, I'm just guessing. Let's say the 2.5-year look back starts September. Well, if I filed for community care October 31st, set up a trust and put everything in there, I'm not subject to that 2.5-year look back. But the second I file on September 1st, I mean, October, I did that wrong. What's August, September, August 31st, I can do all that. September 1st, I've lost that opportunity. So there's no grant, if you could do it right before the law is instituted, you're fine. But the day after, you're subject to the full 2.5-year look back. So that's a little unusual. They usually phase these things in, but this is not being phased in.
Is having a beneficiary on a CD keeping you out of probate?
Can a beneficiary on a CD avoid probate? Yes, if you can put a beneficiary on a CD. That's more of a bank question.
Do you prepare special needs trusts?
I do. Special needs trusts, most of the ones we do are third party, but we can do first party supplemental needs trust. If you don't know what that means, I'm happy to go over it. Those are the two options that would be important. But if you have like a younger special needs child and you're looking for a special needs attorney that can talk to you about all the benefits and educational models and advocates for those type of things, I make no bones about it. I'm in this field more for elder laws. My grandmother had 12 years of Alzheimer's. I'm more familiar with senior types of non-legal benefits and things than I am with special needs children. So depending on your situation, I'm happy to give you the name of special needs attorneys if you're looking for that scope. But just setting up the trust and explaining how it works and making them effective, yeah, we're fine with that.
Should you still do a trust if your spouse is living and the house and assets would pass to them?
Should you still do a trust if your spouse is living? Yeah, I think you should, but like everything else, let's know more about the circumstances. So there's a lot of benefits, and most people set up trusts while the spouse is alive, because maybe you don't understand that there's nothing automatic that goes to your spouse unless it's co-owned assets. So we just had this issue the other day. A man owned the house, he married the woman, he never put her on the deed. The man passed away without a will, or even with the will, I could do both. Without a will, his wife has to go through the probate process and just to find out that she only owns 50% and his children own the other 50%. So that would be without a will. With a will, you still have to go through probate, and then she can get ownership of the house. So most people, though, whether it's co-owned or not, you want to put it in the trust, because we don't know when you're going to pass or what the circumstances surrounding that death is. So the sooner the better. Estate planning is, there's no particular rush. You just got to do it before you die.
Will that have any effect on the trust?
I don't think so, if I understand the question.
Once you obtain a revocable trust, if you gain new assets, do you need an attorney?
No.
To add the assets to the trust already in place?
If it's financial based, then you would work with your broker or banker. So they understand trust. You give them a copy of the trust. You say, hey, I want to put a new bank account in the trust, and it's as easy as opening a bank account. For real estate, you may need an attorney to create the deed, or if you're smart enough, you would have just purchased it directly from the trust.
How does being a veteran with VA medical care benefits affect trust options?
So VA benefits, I mean, if you're Vietnam and Agent Orange related injuries or putting you in a nursing home, you got a free ride. So you don't even need a trust. So how does it affect it? A lot of different ways depending on what type of benefits you're getting from the VA. But the VA is good for like aid and attendance. So if you're getting care at home and you want to increase your income, you can file for aid and attendance. The trust has nothing to do with that. You still are entitled to it. You can still get it. The only difference is if you file for Medicaid, now that aid and attendance is just a payment source before Medicaid picks up the rest. But trusts they play different rules, and something like a benefit like that doesn't disrupt it or change the game plan necessarily.
If assets, bank accounts, stocks have beneficiary transfer on death, does that eliminate the need for a trust?
If you're renting the house, it's less likely a trust is going to have any benefit for you. Like I say, you don't need a trust unless you have some sort of goal. And if all your assets can pass by beneficiary designation, and you've got some mop up probate through the will, like less than the 50,000 I talked about, I don't think you're in a position to need a trust unless the bank accounts, you want to preserve them because you think you'll need Medicaid in the future. So then we would talk about perhaps putting money in the trust so you can qualify for Medicaid, and then your heirs and you still have some money left over despite the cost of care. So it's hard to answer very specific questions about yes or no because there's too many variables. And again, that's what the conversation with the attorney is all about, to identify specific details about the questions you're using and what you're trying to achieve. Most of the answers to these questions, of course, are yes or no, depends.
Is the will the directions for the trust? Is there a cost to updating an existing irrevocable trust?
Anytime you ask an attorney to do something, there's always a cost, right? Good attorneys will be transparent with fees and tell you up front what they're going to charge you for those services. I didn't hear the first part of the question, though.
Is the will the directions for the trust?
It's the will, the directions from the trust. So the will and the trust usually sit separately. So the trust provisions can be completely different from the will provisions because the will is going to distribute different property than the trust. The trust is only responsible for assets held in the trust. The will is only responsible for assets that go through the probate process, and your beneficiary designations are only good for beneficiary designations.
And then the last question we'll take is, are there creative ways to set up home deeds so that they would pass to a child upon a parent's death?
So there's two ways to avoid probate without a trust. And again, depends on what the goals are, because anytime you want long-term care or Medicaid to pay a bill, the next two things I'm going to talk about have pros and cons. The first one is a life estate. There's a life estate is where you give away your house now to someone, but reserve the right to live in the house. We drafted a lot of those before 2006 when they changed the look back period for life estates from 3 years to 5 years. Once trusts were always 5 years. So once back then we were willing to basically use an inferior product to get over the look back sooner. So the life estate is not as good as a trust, but you went through the look back quicker. Now that they're both a 5-year look back, I tend to use just the better tool, which is the trust. The life estate, the downfalls of the life estate are control, and if you sell it while you're on Medicaid, there's a value to the life tenant, which would disrupt Medicaid benefits. I don't want to go into detail now with it, but those are two issues you don't have with the trust, and they can be pretty big issues. There is a brand new law from July that is New York State has introduced a transfer on death deed. That is where it's not a life estate where you give away your house to someone else now and just retain the right into it. It's literally a beneficiary designation on an existing deed. The reason I'm not promoting a lot of them yet, but it could be a really good game changer. I love the concept because doing a transfer on deed is going to be a lot less expensive than doing a trust. But it's kind of like the first year model of a car. They threw it out there and they're waiting for the public to pick out all the problems with it. I'd like to see them work out some of the bugs on the statute before I really go to town on it. The biggest problem with transfer on death deeds are most people, if you have 2 or 3 children and one of them, God forbid, predeceases you, usually your grandchildren from that predeceased child receives their 1/3 or half share. Transfer on death deeds don't work that way. All 3 if one of the children passes, the other gets 100% of the house value. It's not until when all children pass away until you can get down to the next level of beneficiaries. And that's just not the distribution strategy most people want. I've done one transfer on death deed, and it was with an only child situation where I said, you know what, I think you're fine with this. They didn't want Medicaid planning, and they only had one child, and they only had one house. So that's the only time I've drafted one or endorsed one. We'll see how it works. I have to wait for this poor woman to die, but we'll see how it goes.
And lastly, do you have a booklet with step-by-step processes to help guide with questions to help create a basic trust?
Step-by-step process on how to set up a basic trust. I don't have anything like that. You're welcome to go on my website. It's got a lot of good articles, information. Like I say, doing trusts on your own would be not advisable. But the steps to creating trust are identify a goal that a trust can meet, and then talk to someone who can actually draft those trusts so that they can walk you through that process. My website, by the way, my name again was Craig Andreoli. I'm from the Andreoli Law Group, and the website is www.andreolilaw.com. And I think we're over time now, John, but that's up to you, I guess. I have a little bit more time if you need it.
We thank everyone for all the great questions. Any questions not answered will be sent to our Suffolk investment team. We thank everyone for attending and for their membership. We value each of you. We thank Craig for the knowledge and the important information he shared today. If you have any additional questions, feel free to contact us at the website on the screen, or you can just scan the QR code. Thanks everyone for joining us. Have a great night.
Thanks everyone. Bye-bye now.